Great, so welcome everyone. My name is Katie Gonzalez, and on behalf of the organizing committee for New York Arbitration Week, we're delighted that you could join us today. New York Arbitration Week is organized every year on behalf of the New York International Arbitration Center, or NYAC, and the Chartered Institute of Arbitrators New York branch. The incredible programming brought to you today and throughout the course of this week is made possible by the support of our financial sponsors, you can see on the next screen, as well as the participating organizations who are listed on the following screen. And we want to give them a big thank you for all of their support and the assistance that they've provided in making New York Arbitration Week possible. I want to give a special shout out to FTI and Michelle in particular on this Zoom today, who is our remote host for New York Arbitration Week, and they're helping us with this session and every session throughout the course of the week. So thank you very much to FTI. On a logistical note, if you have any questions, please put them in the Q&A function, which we'll be using throughout the webinar and the debate that we're having here today. That's at the bottom of your screen. We also will have the chat open, so if you wish to introduce yourself or become a part of the debate, please feel free to leave a message. You would have also have received some CLE credits since we are offering CLE credits for this program. And if you received the forms via email today, you can submit those at the conclusion of this program. And if you did not receive the forms, they're available on the New York Arbitration Week website, along with some articles on the topics that our debaters here will be discussing. So I'm very excited now to introduce this program to you, which will feature a debate on two hot topics in technology arbitrations. And this debate has been coordinated and planned by the Silicon Valley Arbitration and Mediation Center, or SVAMC. And without further ado, I will turn things over to Michael, who will provide a brief introduction into the incredible work of SVAMC and also give you a brief background into the bios of our illustrious debaters who are joining us today. Thank you so much, and over to you, Michael.
All right, well, thank you very much, Katie. And thank New York Arbitration Week and the committee for organizing this program. I am Michael Diamond. I am right now sitting in Shaker Heights, Ohio. I am filling in for Tom Halkert, who was advertised and to be a debater. We are all involved and all on the tech list of the Silicon Valley Arbitration Mediation Center. I'm proud to be on the exec committee, and Tom is recovering from an illness, and we're all wishing Tom well. The Silicon Valley Arbitration Mediation Center is a nonprofit organization which promotes ADR in the global technology sector. We do many things. Among others is we vet technology arbitrator and mediators, people with enormous amounts of experience. And we publish that list called our tech list. We also have supporters from law firms around the world on our general membership. I suggest that everyone who is interested in tech ADR and resolving matters through tech ADR to look at our website, www.svamc.org. And now, without taking anybody's additional time, we have a really exciting set of two debates. And we have four very qualified and very experienced debaters. The program is going to be as follows. There is 10 minutes allocated to each debate. Before each debate, or 20 to each side of each debate, it's 20 minutes to each debate. Before each debate, we're going to take a vote as to the attendees' feelings on the approval or disapprove of the resolution. We're going to have the debates, 9 minutes affirmative, 9 minutes negative, 1 minute rebuttal for each side. Take a second vote and see if any minds are changed. And then we'll move on to the second debate. So without any more background, let's go and do the first debate. And I will introduce the topic and the debaters. The first debate, resolved, the Prague Rules contain approaches to experts and the role of arbitrators that are better for arbitrating technology disputes than the IBA Rules of Evidence. In the affirmative is Duarte Henriquez, who is in Portugal. He's a lawyer and arbitrator in Lisbon and a partner in Victoria Associates. He's a member of several international associations, including LCIA, IBA, ICC, ICCA. He's on the ICC Task Force for Financial Institutions. But most importantly, he was a member of the working group that helped draft the Prague Rules. He's also a proud member of the tech list is appointee on the tech list of Silicon Valley Arbitration Mediation Center. The negative debater, though he's not a negative person, is Bill Baker. He's independent arbitrator and mediator in New York. He's a member of the College of Commercial Arbitrators, former adjunct professor at Cardozo Law School, listed Best Lawyers of America, International Arbitration. He co-chairs the International Litigation Committee of the ABA and chair of Arbitration Committee of the Intellectual Property Association. Before being a full-time arbitrator mediator, he was at Fish and Neva and at the New York office of Ropes and Gray and Alston Bird. Bill is also my co-chair. He and I co-chair the program committee of the Silicon Valley Arbitration Mediation Center. And we are now, I have a timer, so everybody is aware. I'm going to give everybody 1 minute. When their 1 minute is up, you can watch, the debaters can see my hand. And I'm now going to go directly to Duarte. Oh, by the way, before I say this, Bill had knee surgery. And if you see Bill getting up and walking around or going off screen, it's because he's got to stretch his knees, having pain. He could be having issues with his pain. His surgery was Friday. So we're really pleased he could still make it today. Let us now go directly to the first debater in the affirmative. Duarte?
Hello, good evening, everybody. I'm deeply sorry, but I'm hear some sound in the background. I can't.
You want the poll first.
Oh, I'm sorry. You're right. You are right. I apologize. Bill, I got the whole schedule in front of me.
Okay.
Michelle, can you do the first poll?
Yeah. It seems that I can't vote.
That's correct. Panel can't vote. That would be weighing the thing. That would be definitely wrong.
And we are going to get the results of this poll, right?
Yes, we will get the results of the poll after we'll get the results of both polls afterwards. We don't want to prejudice you and think you are running in the deficit. Michelle, are we good to go? I'm guessing the poll is off and I'm going to start. Duarte, your 9 minutes start right now. Oh, here it is. We do get a result.
Oh.
That was wrong.
Disagree.
Disagree.
Disagree
All right, so
winning.
you're going to overcome a deficit if you can.
Yeah, so my task now is to overcome these preliminary results.
Okay.
In trying to show. Thank you. Thank you so much for this opportunity and for this kind of introduction, Michael. Yes, my task here is to convince people that indeed Prague rules are better suited for international arbitration when dealing with technology disputes and disputes among technology companies. The basic tenet that was underpinning the works of the task force on the Prague rules, the committee, was that somehow international arbitration was too much influenced and got a big amount of impact from so-called traditional US-style litigation. There was a perception that international arbitration had become more and more influenced by the American style of litigation in US courts, and therefore international arbitration was getting a lot of their resources and like extensive evidence production and discovery and witness cross-examination, which are not very common to the so-called European style, which tends to be more flexible and more swift in terms of production of evidence. So that was basic tenet, and this background concealed the perception that arbitration was also too costly and too time-consuming in getting the desired results. When it was announced that arbitration would bring a result, an outcome in a fast and cost-efficient manner, we saw that indeed international arbitration cases and traditional procedures were getting indeed more time and more money to get the result. So basically, The Prague Rules wanted to convey the message that arbitrators need to be more proactive, need to be a better grip of the procedure, and trying to conduct the proceedings in order to have an expedited outcome of this procedure. You can find a few features of the Prague Rules that show this underlying mindset of those sets of rules. One is the powers that are given to arbitrators right from the start in the first case management conference, where arbitrators can make some sort of cleaning as to the facts that are going to be subject to the production of evidence, like separating those facts that are undisputed from those that are going to be disputed. And arbitrators can also, in certain circumstances, share some preliminary views without jeopardizing their impartiality and independence. Preliminary views on the allocation of the burden of proof between the parties, the release of disputed issues, and the weight and relevance of evidence submitted to the parties. Also, arbitrators may exercise their powers in the fact-finding there is in trying to get from the parties facts or production of evidence of facts that the tribunal deems to be relevant and material to the resolution of the case. Also, arbitrators can appoint experts and in some cases use the powers labeled as jura novit curat, there is to apply on their own motion provisions of law that were not alleged by the parties. And also, arbitrators are encouraged to facilitate settlement, which does not mean that they will act as mediators, unless the parties agree, of course, in their doing so, but they can try to convince the parties to settle the case without, again, jeopardizing their independence and impartiality. So, but the question here for our audience is to know how much more fit to technology disputes are the Prague Rules. I will start by one feature that I've already mentioned, and which is connected with the mindset of the Prague Rules to avoid extensive evidence production and extensive and full-blown discovery. For companies, for big companies, they would not want to have full-blown discovery, especially in tech companies. This might be a very hard issue to deal with, and they will be most inclined to not accept discovery and therefore to go and be linked to the more European or more civil-like law tradition of not getting a full-blown discovery. Also, the fact that the tribunals can appoint experts can have a very productive outcome, because arbitrators will most likely be in the better position to know who is going to be the expert who can help them in deciding the case. On the other hand, and as I mentioned, because arbitrators are advised to and encouraged to have a more proactive approach and to the management of the case, they can have and exercise this muscular approach, and therefore facilitate, and therefore have a procedure that could save costs and time. And of course, this is one of the features that tech companies usually seek in dispute settlement mechanism. And finally, most companies, and I see this in my experience, including with the US companies, wish to have some sort of facilitation of settlement during the procedure. And this is something that they will most likely be happy to find in these procedures, because they'll know that at any time they can have the assistance of the tribunal in order to get a settlement. And with this, I rest my case, and I hope that I have convinced the audience to change that part of the audience that has voted against the motion to change their views and to see that indeed the Prague rules are a very positive instrument in having a good, expedited and cost-safe procedure for solving disputes. Thank you.
All right, thank you, Duarte. You haven't had a minute left, but that was very efficient. Well, I want to.
So this is to show that the Prague rules do indeed work.
I'd like to tell all the attendees that if they have any questions for any of the panelists, that they to enter them into the questions in the bottom of their screen, and we will be monitoring them. And when the debates are over with, we will be trying to. We'll have about 10 or 15 minutes left, hopefully, to answer them. Now, Bill Baker in the negative.
Thank you, Michael. Good afternoon. The Prague rules, consistent with trial practice procedures in civil law countries, as Duarte has said, gives almost complete control to the arbitrator, not to the parties, not to their lawyers, in determining how the arbitration shall proceed. The Prague rules also tend to favor tribunal-appointed experts, not party-appointed experts. And I respectfully submit that these two problems, these two issues, result in a set of rules that are ill-suited for complex high-technology cases. So what are some of the problems then for high-technology cases? Well, first, the Prague rules will not likely allow adequate discovery for complex technological cases, and they require document requests to be formulated too early in the proceedings. In particular, Article 4 deals with documentary evidence. It states, and I'm going to read at length, each party shall submit documentary evidence upon which it intends to rely as early as possible in the proceedings. Generally, the arbitral tribunal and the parties are encouraged to avoid any form of document production, including e-discovery, any form of document production. However, if a party believes that it would need to request certain documents, it should indicate this at the case management conference. And I should point out, by the way, the case management conference under another rule is mandated to take place without any unjustified delay after the pleadings. So it follows hard and fast on the filing of the case, or should. The rules go on to say a party can request the arbitral tribunal to order document production at a later stage of the arbitration, that is after the case management conference, only in exceptional circumstances. So as you can see, Article 4 expressly discourages document discovery altogether and requires it to take place too early in the case when you have a complex case and you're still formulating your facts. But even if you do get discovery, what discovery are you likely to obtain under the Prague rules? Well, Article 4 states, a party may request another party to produce, and again, I'm quoting, quote, a specific document, which is relevant and material, and the tribunal may order it to produce, quote, the requested document. I respectfully submit such limited production of specifically identified documents is simply not appropriate in technology cases where much of the information is often in the possession of the other party. Now, I agree with Duarte that there's often too much discovery in American litigation, and that is infecting arbitration too much. But let's don't throw out the baby with the bathwater. And some of these rules set up a situation where you may end up with precious little discovery. The limited discovery is made even worse by Article 8 dealing with hearings. This rule states, in order to promote cost efficiency and to the extent appropriate for a particular case, the arbitral tribunal and the parties should seek to resolve the dispute on a documents-only basis. No witnesses, just documents only. They should seek or try to do that. Thus, not only do you risk not obtaining sufficient documents, but you may be stuck with only the documents you have obtained in a documents-only hearing. Now, it's true that Article 8.2 does go on to permit a party to request a witness hearing. The rule does not expressly require the tribunal, however, to grant that request, and it's very possible, depending on the tribunal, that it may not. So what's the second problem? The second problem is very similar. The Prague rules require more specificity regarding who your witnesses are at the outset of a case than is feasible in a complex high technology matter. Article 5, which deals with witnesses, states in part, and again, I'm going to quote, when filing a statement of claim or defense, and I'm quoting excerpts, a party shall identify each fact witness and the substance and materiality of his testimony. That's in your pleading. In a complex case, one is obviously not going to know each fact witness and the substance and materiality of their testimony and be able to lay it out in your pleadings. At least I couldn't. Although Article 5 does permit identification at a later stage that the tribunal deems appropriate, it may not consider a later stage appropriate. And if it does, it's highly likely that that later stage will be the initial case management conference. So thus you are stuck with a situation where parties are just not going to know who their witnesses are, precisely what they're going to say, and what the relevance of their testimony is at either the filing of the claim or at the initial case management conference. I think one quick example may show the problems that this could cause. In a patent infringement case, just to take a hypothetical, governed by US law, one can seek to declare the patent invalid on the grounds that the invention was, quote, in public use, on sale, or otherwise available to the public, close quote, more than 1 year before the filing date of the patent application. Well, you're not going to know, however, if the invention was on sale by the inventor or used in public by the inventor, or who the witnesses were to such public use without some substantial discovery that's going to take more time than just the initial case management conference. Thirdly, as Duarte has said, the Prague rules will likely or often result in a court-appointed expert. This is consistent with the practice in civil law countries where the judge often appoints the experts. There are benefits to this, but in my opinion, having two separate party-appointed experts working intensely over an extended period of time with their respective counsel is more likely to bring out all the facts, all the arguments, both pro and con, than is one expert appointed by the court. I should add that Article 6.5 states that the appointment of an expert by the tribunal does not preclude a party from submitting his own expert report. But as a practical matter, once an expert has been selected by the tribunal, that expert is likely to be given controlling, if not dispositive weight. So let's contrast some of these problems with the Prague rules with the IBA Rules of Evidence. The IBA Rules of Evidence, although not perfect, were drafted to create a compromise between overly limited discovery, I would suggest, in the civil law countries, and overly broad discovery in the US. For example, in dealing with document discovery.
One minute.
Okay. The IBA rules do not favor US types of broad requests that seek any and all documents relating to such and such a subject matter. You're just not likely to get that from an average tribunal in an IBA case. Instead, they permit only narrow and specific requested categories of documents that are, quote, relevant to the case and material to its outcome. I suggest that this is sensible and more appropriate to technology cases than the extremely limited document discovery under the Prague rules. Likewise, Article 4 expressly provides for the testimony of live witnesses. Although the tribunal has the authority to shorten the hearing by requiring witness statements for their direct testimony, the other party who presents them must make them available for cross-examination at trial. So you're guaranteed live testimony if you wish it. Finally, Article 5 grants the parties the right to rely on party-appointed experts, gives them the right. So,
Time.
in conclusion, can I give 2 seconds?
2 seconds. All right.
In conclusion, I submit that the Prague rules are simply ill-suited and not as well-suited as the IBA rules for complex technological cases. Thank you.
Thank you. By the way, before the rebuttals, 2 things. Anybody with questions, again, please put them in the question and answer. In addition, at the end of the second debate and sometime after the questions we discuss, I will be giving the code for CLE for those who need it. I have it here and I will be giving it. And if for some reason I don't, one of my colleagues will then give me a kick and tell me to do it. Duarte, your rebuttal. Give you a little leeway because you didn't take all your time before.
Thank you. Even with 2 minutes, I think that Bill has raised so many issues, so many attacks against the Prague rules that I just want to pick in 1 or 2 points. But I would say in general terms that if we were in a courtroom or before an arbitral tribunal, Bill was more concerned to attack the Prague rules rather than to champion the alternative or the alleged alternatives, which are the IBA rules. And I frankly do not see how can we show that the IBA rules on the taking of evidence are better suited for technology disputes. But as Bill said, the Prague rules do not prevent parties from presenting witnesses and experts and party-appointed experts. But the question here is, when you present your expert report or even you cross-examine your expert or examine your expert, what's going to be the outcome for the tribunal? What's going to be the conclusion that the tribunal is going to draw from their statements? We know that party A is going to bring an expert that is going to say 100, and party B is going to bring another expert that is going to say just 1 or 0. So in what to which extent does this help the tribunal in deciding? So my principle and the Prague rules tenet is that because we are going to have arbitrators that can understand and do understand the nature of the dispute, the nature of the area of law that is in dispute, they are in better position to choose and to conclude from the contributions of the experts who is going to be in better position to help them in deciding. Thank you.
Well, thank you, Duarte, and we'll now take a vote.
1 minute.
Bill,
I get rebuttal.
You had your rebuttal. No, you get your. I'm sorry. You get your rebuttal. Yes, you get your 1 rebuttal. I'm losing track because I gave Duarte an extra minute because of the time before. Yes, go ahead.
I'll be short. Thank you. I would again agree with Duarte that there's too much discovery infecting arbitration, and the IBA rules are not perfect. They could certainly use some tinkering. But as I said earlier, let's not throw out the baby with the bathwater. And the structure of some of the rules, the Prague rules, are such that you may end up with absolutely minimal to no discovery. Now, Duarte also mentioned something that I didn't mention, but I'll respond to it, that the arbitrators are allowed to act as mediators in the middle of an arbitration. I'm all for mediation. I'm a mediator myself, but there are times where you don't want the finder of fact switching hats and becoming a mediator, especially if it's not in a common session. He's hearing private items that the other side is not able to respond to. So I think that can be problematic, but you might be coerced in saying, okay, let the judge do it, because if I don't, we'll have problems. And then you end up with 2 people left to decide rather than 3 if he's disqualified.
We now have a vote. Thank you both. I mean, I sympathize with both of our debaters who probably needed triple the time to go into this complex issue, but I think they did a wonderful job in the allocated time. So if everyone would please vote, and we'll see if anybody's mind was changed. Okay.
I see that I was a lousy advocate in defending this cause.
I think Bill is the winner, but this is still an issue which parties disagree and can pick their rules. It isn't a question of right or wrong. It's a question of what people think works better for their disputes.
Horses for courses.
Yes, second debate. The second debate, which I have now, is resolved. Publication of arbitration awards by administering organizations is beneficial to the arbitration of technology disputes. And we have 2 distinguished arbitrators again. We have Criguta Liu, or Liei, I should say, who is in Bucharest, Romania. She is a experienced arbitrator and a founding partner of Lui de Macali, Diacanu, and Ponescu, and I apologize for the pronunciation. She's a vice president of the ICC International Court of Arbitration, member of the ICC Commission on Arbitration, as well as a member of a number of task forces. In 2017, she was named a thought leader in international arbitration by Who's Who Legal. She's a co-author of co-author of 5 books, 50 articles on topics of international arbitration, intellectual property, construction law, commercial law, and corporate law. And now she is the affirmative. The negative is Angela Foster, who is certified as a mediator and arbitrator. Angie has adjudicated over 500 disputes involving patent infringement, validity, licensing, commercial, business ventures, breach of contract, negligence, and on, trademark, etc., IP issues. She's a member of numerous arbitration panels, including AAA, CPR, WIPO, FINRA, ICDR, and also, as with Criguta, she's on the tech list of Silicon Valley Arbitration Mediation Center. She also serves on AAA's council. She's the immediate past chair of the dispute resolution section of the New Jersey State Bar. In addition to her law degree, if the other didn't impress you enough, she has a PhD in biochemistry and molecular biology. So as a further commercial for the Silicon Valley Arbitration Group, we're not just hard computer science. Angie's a biologist, and a lot of the tech list people have all kinds of tech science backgrounds. All right, again, let's have a vote. Publication of arbitration awards by administering organizations is beneficial to the arbitration of technology disputes. And again, I invite questions in the questions and answers. The chat is for people to socialize with each other who are attending, but questions for the panel should be in the Q&A. Okay. So the agree side says we should publish awards, and Criguta, that's your side. So let's see what you have to say. You have your 9 minutes starts now. Your mic.
Yeah, thank you.
All right, now I'll start you again.
Yes, good afternoon. And since my role today is to present arguments in favor of the publication of the arbitral awards by administrating organization as beneficial to the arbitration of technology disputes, I can see that the poll at the beginning is favorizing my position. So I'm very much hoping to keep it after my arguments. The main arguments in favor of publication of the arbitral awards in general are in fact policy issues, if you look at them carefully, from the perspective of the administrating organization and from the perspective of the arbitration community, aimed to the promotion of arbitration. But that is not for a reason that wouldn't be supported by the users of arbitration. It is precisely in order to respond to their needs. And I will refer to three such arguments: transparency, predictability, and contribution to the general advancement of the legal knowledge. Transparency is a requirement of the modern world, particularly in disputes where one of the parties is a state or a state entity. Citizens of countries facing significant financial impact of arbitral awards demanded such transparency, as it is about the public budget that they fear the arbitration is taking place absent the public scrutiny. This is something that was developed particularly in the investor-state arbitration, where such arbitration was heavily under public pressure for transparency. But then the public pressure slowly migrated also to the commercial arbitration involving states and state entities, to finally reach the overall tendency of the user's expectations, absent, of course, a specific choice of confidentiality. Maintaining trust in arbitration of the general public is crucial in maintaining the overall support for arbitration of states through their legislative bodies, first of all, but then the courts of law and the state institutions in charge with enforcement of arbitration. Absent such trust, arbitration in all the aspects, including technology related, would not be possible. Predictability. The second argument for publication of arbitral awards is one of the needs of the economic environment in particular, so of the traders. Facing the need to be able to assess the financial risks in case of a dispute, traders are increasingly demanding for a risk analysis based on the relevant case law. While data exists and it is becoming more and more available for the courts of law, even in the not so advanced economies, it is not the same situation for the case law of arbitral institution. It is very recent that various organizations started to gather data about the case law in arbitration. Therefore, publication of arbitral awards would allow the users of arbitration to enjoy similar predictability with that they already have for the courts of law. It is therefore not anymore about an advantage of arbitration. It is merely catching up with the possibilities offered already by the courts of law. The third argument, contribution to the general advancement of legal knowledge, is another major reason in favor of publication of the arbitral awards. Arbitrators are usually professionals of high reputation, legal minds who, over the years, contributed significantly to the development of international trade law. Lex Mercatoria and the general principles of international trade law greatly benefited from the legal thinking of such arbitrators. But what if the dispute is a technology-related one? Are these arguments that I already presented still valid? In the context of our discussion today, I shall refer to technology disputes as disputes where the core issues are technology-related and not necessarily disputes that would have as parties companies in the technology industry. Such disputes have usually a number of characteristics. They are heavily factual disputes, or at least disputes where parties present a significant amount of facts that they are technology related. They include expert reports on the technology matters relevant to the case. They tend to be case specific, namely the issues in dispute do not reiterate in a large number of other cases. And a significant part of them are in somehow referring to intellectual property rights, mainly in the context of research and development agreements or license agreements that usually include confidentiality in the arbitration agreements. In such context, I admit that the natural tendency would be to consider that publication of the arbitral awards would not be particularly useful, might be considered a danger to proprietary information, and it may even violate the confidentiality requirement in the arbitration agreement signed by the parties, particularly in intellectual property contracts. However, there are a number of reasons for which such publication might be considered beneficial, and I will refer only to three of them. The first reason is based on the fact that producers and users of new technologies may need to rely on arbitration rather than the courts of law in case of rapid advancement of technology, because this advancement of technology is faster than the rules of law. In such case, the new technical realities are building new realities in economy, and the rules of law are not yet adapted to those. Parties may wish to rely on a decision based on fairness or in ex equo et bono, which in many countries may be available only in arbitration and not in the courts of law. Arbitral awards in such cases may be of crucial importance to the advancing of the formation of lex mercatoria, paving the way for the later intervention of the state legislative bodies. The producers and users of products and services related to such new technologies would particularly need a legal framework that is clear for their activities, and publication of the arbitral awards would contribute in this respect. A second reason for which the publication of the awards would be beneficial in technology-related disputes is that it may be that these disputes are not necessarily heavily factual. Facts and legal issues may be much more intimately interlinked than in other types of disputes. Some of the new technologies are actually embedding moral, ethical, or even legal choices. Some new technologies, such as the blockchain or more general distributed ledger technologies, are even the technical support for the contractual relationship between the parties in the form of smart contracts. Then the legal issue is not actually a purely technical issue, but it is a legal one too, to be related to a specific legal provision or referring to the legal protection of moral and ethical values. Artificial intelligence, automation, and smart contracts are particularly prone to provide a mixture of legal and factual issues. Just think at the instructions that are given through the programming of a self-driving car by either the producer or the user at the time of setting that car, or the situation of a smart contract, which is a self-executing contract, and the same instructions may be in dispute, including the legal, moral, and ethical issues related to the parties' automated behavior. Publication of the arbitral awards in such issues would be in particular useful, as such matters may be highly repetitive, so that its publication would help adaptation of the producers' and users' behavior, ultimately preventing similar disputes.
1 minute.
A third reason, and last one, for publication of the arbitral awards I would like to mention relates maybe counterintuitively to intellectual property disputes. In many cases, the applicable law for such disputes, such as copyright law for software as well, include among the remedies for the moral damages related to the violation of intellectual property rights, the publication of the award. In such cases, absent the possibility to make the arbitral awards public, the very enforcement of the awards would be prevented, because one of the decisions of the tribunal on one of the prayers of relief would become impossible. And that would rest my three arguments specific to this kind of disputes.
Thank you, Kranguda. We're now going to have Angela for your 9 minutes.
Thank you. Publication of arbitration awards by administrating organizations is not beneficial to the arbitration of technology disputes. This debate is not new, nor are the reasons technology companies have chosen arbitration over litigation. So why do parties involved in technology-related disputes choose arbitration over litigation? Confidentiality has and continues to be a significant consideration for commercial parties in seeking arbitration over commercial litigation. In 2009, the American Arbitration Association conducted a study that evaluated the most important goals for companies when a dispute arises with clients or suppliers, based on 14 categories. Confidentiality ranked as the fourth most important factor for all surveyed. Interestingly, confidentiality was followed by expertise of mediators and arbitrators. Oftentimes, parties involved in complex technology-related disputes are business competitors and or allies, depending on the day. Consequently, maintaining business relationship regardless of the outcome is important. Accordingly, keeping decisions to awards out of earshot or eye view of competitors is equally important. The concept of publishing arbitral awards was born out of the investment industry, which has merit because the respondent tended to be a country. Thus, if a claimant company succeeded on an arbitration, the respondent country would pay the award. Thus, citizens of that country had a vested interest in the award and its information. Unlike investment disputes, technology-related disputes usually involve two companies and very sophisticated parties. International arbitration has traditionally been private, but not always necessarily confidential. Publication of unredacted decisions will certainly diminish this desire. Even when decisions are just summarized or published in a heavily redacted form to eliminate party and arbitrator names or specific facts, that may not hide enough information to make it private enough for the party's desire. So why do parties involved in technology-related disputes choose arbitration over litigation? Cost and efficiency has been also an important factor. Publication of awards could result in increase in cost due to editing needed to publish the award. What was once considered a less expensive option to litigation could change. Selecting and editing awards for publication could incur significant costs and could impact administrating organizations' decision on how much to redaction should be needed. The decision could influence whether a sufficient party's identification or information is eliminated. Law firms with large international arbitration practices can develop files and institutional knowledge about arbitrators, administrating agencies, and procedure customs that are often not readily available to smaller firms. On its face, this may appear that publication of arbitration awards would level the playing field. However, access would depend on the cost of the access to the publication and the degree to which publication decisions are redacted. Smaller law firms may not be able to afford the subscription to any institution for publication, and at the very least, parties would incur unexpected costs. So why do parties involved in technology-related disputes choose arbitration over litigation? Because arbitration is not litigation. Publication of arbitrator awards could mirror litigation. Some argue that arbitral awards were published if they were published as a matter of law or course, the decision could contribute to the development of law. And the common law would not be missing significant bodies of decisions by arbitrators. Arbitrator award and decisions have had no precedential value, neither will with respect to procedural decisions or interpretation of the law. Albeit grounded in controlling law, technology-related disputes are heavily fact-sensitive. Publication of these decisions would not add a substantial benefit. Moreover, parties in an arbitration seek guidance from the law and cite them accordingly. Arbitrators' decisions can never have the same value. One may argue that publication of awards could contribute to a uniform application of rules, providing enhanced consistency or certainty. However, to what extent are past awards of any actual value in terms of how arbitrators decide the merits of a dispute? Decisions of substantive issues rarely prompt references to past awards. Instead, parties usually refer to past court decisions or academic writings. Moreover, courts are not bound by decisions from other courts. So why should arbitrators be bound by decisions by other arbitral panels? Publication of awards could impact the content and style of the awards. An arbitrator who knows that his or her decision is likely to be published may write it differently than if he were to write this with the intent to the parties to understand this decision and the reasoning. Some believe that the knowledge of the awards were being published would prompt arbitrators to write a coherent legal factual decision on findings. However, publication could impact the form, the substance, and the length of the awards. Arbitrators writing for a broader public audience than just the parties before them may tend to write awards that are longer and that are driven by considerations that are not involved in that particular case. Again, increasing the cost of the arbitration. Although a small number of our administrating agencies disclose the arbitrator's name, the same issue can occur even if the arbitrator's names are not disclosed. For example, sophisticated law firms may employ companies to study and determine which arbitrator wrote which decision. Publication of awards could promote what's called the in crowd or the club of neutrals. Another important advantage of arbitration is that the ability of the parties to choose their decision maker. This is extremely important for technology-related parties seeking particular expertise in legal and or scientific area being disputed. There is a concern that the lack of publicly available information creates an uneven playing field because larger companies have access to people with experience with numerous arbitrators for recommendation, thus giving large companies an advantage. If the names of the arbitrators are disclosed in published decision, that advantage would only increase. Arbitration is not litigation, and nor has it ever intended to be litigation. Resolved, publication of arbitration award by administrating organization is not beneficial to the arbitration of technology disputes. Thank you.
Thank you. Now, Kranguda, you've got 1 minute to rebut.
Thank you. It's difficult to follow Angela's excellent presentation, which now I fear we'll switch the votes from the beginning, but I would like to address 3 points. First one, the lack of value as precedent of the arbitral awards. Yes, indeed, they do not have the value of a genuine precedent, but they do have other type of values. I call them the 2 P's, P from persuasive and P from predictive value, both of them matching, in my view, the precedent value. So you can persuade another person based on the arguments that were explained by an arbitral award or in an arbitral award by an arbitral tribunal, and by that they can be predictive. And the second point that I would like to make is related to confidentiality. I do believe that redacted versions of the arbitral awards agreed by the parties might be a good answer to find a common ground between the 2 conflicting points. And the last point, states are not parties only in investment arbitration. Nowadays, states are investing heavily in technology, so they may be parties in commercial disputes as well.
All right, thank you, Kranguda. And Angie?
Thank you. Trying to make sure I'm not muted here. Okay, I'm going to try to address 2 or 3 of her points if I can, but definitely the point that she talked about persuasive as well as predictability. One of the concerns has been that as I mentioned before, the in-crowd versus the pool of arbitrators, which is a club. Because it's thought that the same pool of arbitrators are appointed, there is a concern that arbitration appointments lack diversity. And so one suggestion is that if you disclose these arbitrator names, that you would widen the pool and inform parties of the choice of arbitrators. I don't think publishing awards is the way to do it. And I don't know if I agree that the predictability or persuasive argument that my counsel has just reiterated would do that. Instead, I think it also increases the lack of diversity. As I said before about predictability, she said they would predict, but the arbitrators are not bound by the ruling of another panel. So therefore, I don't see how there could be predictability. The other thing too is that publishing of the boards could also create some kind of bias. As my esteemed colleague just talked about predictability, parties may end up trying to use those decisions that were made before as a bias to challenge the award with the arbitrator. Thank you.
Well, thank you. Boy, you did 1 minute to the second. You have your built-in time clock. All right, I want to thank all of our debaters, but I'd like to get a vote on the second debate before we go on and tell the attendees that we are looking for questions. Right now, there were a couple of questions that were directed to a particular debater who answered them in writing. If anybody has any questions they would like answered by anyone on the panel, please put them in the question and answer. Okay.
Yeah.
You have Angie, you did an effective
Yeah, it's
argument.
close. It's close.
You
it's
moved
close.
out to a tie, which is not inconsistent with general discussions among our colleagues. Everybody,
That's
you
right.
got your. These are all open issues. Before we go to any questions, and right now there aren't any. So if we don't, before we go to any questions, I'm going to tell the attendees. Oh, there is a question now. The attendees, the code for your CLE is 67 Tech. That's 67 TECH. 67 Tech. Let's see what we have in the. Oh, all right, here's a question from Varashali Sharma. Duarte's typing an answer, but I'm going to state it anyway. Can both Prague and IBA rules serve as guidance as required by a particular case instead of picking one at the beginning? Duarte, why don't you answer that for everybody?
Yeah, well, I was typing, but I can reply here on live, and I think that yes, we can pick. And actually you can cherry pick the features of one set of rules and from one to the other, so you can use both, and you can use that from the outset of the case or during any stage of the proceedings where the tribunal deemed to be fit this picking of rules.
All right, and finally, there was an earlier question, Duarte, that you answered in writing, but I think it's also a good question for the group, and that is, when is the time to pick your rules? In your original agreement, before the dispute, or afterwards? What is normal in these kinds of cases that you've seen? Or
usually what I honestly see is that our arbitral tribunals pick the IBA rules at the first case management conference or during the drafting of the terms of reference when we come to ICC arbitration. So usually that's the most common choice, is to pick the IBA rules, and to do that at the early stage of the proceedings when the tribunal is constituted, or in the first case management conference, as I said. But you can do that along the way, and when you, or better said, you can do that before and to provide the choice in the arbitration clause. I have seen at least 2 or 3 cases where the parties have chosen to use the Prague rules. Of course, there were parties coming from civil law jurisdictions that were already aware of these Prague rules, and I also have seen cases of arbitration clauses coming from other parts of the world where the parties have chosen the application of the IBA rules.
All right, are there any? I don't see any other questions. Does anybody else have any questions for any of our 4 panelists? If not, let's go. Oh, yes, there's some new questions coming up.
I can pick on Paul Mason's question. He asks if these Prague rules are better suited for ad hoc arbitrations, and I think they are. I really do think that they are. And here in ad hoc arbitrations, arbitrators are not so constricted by the institutional framework, which somehow compels arbitrators and practitioners to go to a more well-known and more used set of rules, such as the IBA rules on taking of evidence.
And there was another question that Bob Bartkus, wasn't a question so much as a comment, but I think it's an important comment. What he said is, I thought that Angie's last point was quite powerful, that published awards can be used to challenge subsequent or other awards once sophisticated parties have figured out who were the arbitrators of the parties.
I may address that?
Yeah, I was about to ask you if you could address that.
Yeah, I was thinking that's an excellent point, and it's an excellent remark as well. The thing is that I don't think that the publication is generating the challenge. Is the mere existence of that arbitral award. So hiding an arbitral award is not a legitimate way of thinking, I would say, because it should be a disclosure that the arbitrators or the parties, as the case may be, would have to make as far as that previous arbitration award is concerned. So I would say that publication in itself doesn't change anything in terms of subsequent challenge.
Can I throw a question and make it a little more complex? I think clearly if you issued an award against any other of the parties, and that's clearly something that needs to be disclosed. But what if you have just issued awards one way or the other on particular issues? You know, there are common issues in technology or patent or those kinds of cases. And if they read the award, they would see that you ruled against the plaintiff, the defendant, the patent owner, the challenger, et cetera, several times. And that isn't generally disclosed. How would that affect your thoughts, both Krengouda and Angie?
Well, this is quite frequent in the construction industry, for instance, where it is almost a very clear pattern of arguments on one and the other side, and a great number of cases. But in those cases, basically it is for each of the parties to assess at the time of the appointment of the arbitrator whether they wish to challenge that person or not. It's on case-by-case basis. And I don't think that the publication in itself should hide the reality, or the lack of publication should hide the reality. The reality is there, whether somebody challenges or not, that's a different matter.
Any further thoughts, Angie?
Yeah, I still go back to the concept of the in-crowd and the club, because you can almost start to, I mean, first of all, let's talk about a panel. Unless you're talking about a sole arbitrator, you know, you have a panel of three. In some situations, the chair will write the award and the panel will comment on it, or they will divvy out parts of it. And so to impute whatever was decided by a panel on one person and start to challenge them, I think that goes down a real slippery slope. But I also think that it can further this divide when we start to, we're talking about pretty much forum shopping in arbitration. And so in the investment world, I think that from what I saw, some statistics were showing that challenges were coming up based on prior publications of awards. So I would imagine that the same thing would happen if we were to expand this to just what we're talking about today, which is technology related disputes.
All right, we've used up our time. We ran a minute or two over. I was told we could have a couple of minutes if there are any other questions. If not, I'm going to let me just give it a minute to see if anybody has any other questions. No, I don't see any, but I want to thank all four of our panelists in order with no particular reason other than that's the way they debated. Is Duarte, Bill Baker, Krengouda, and Angela. You've all obviously prepared significantly for the program, did a great job, and we really appreciate your efforts. I hope the attendees share it. Again, on the CLE, in case someone missed it, is 67 Tech, TECH, and the forms are available on the program's website. If they have, it should have been also attached to your link email from the New York Arbitration Week, but it's on their website if you can't find it. And I think that is it. With that, we will end the program. And if FTI can turn off the link, thank you all very much.